Yeah, so I'm sure a lot of you have heard kind of the sequence of events and how we got here. A lot of this kind of came out of us dealing with a lot of obviously turmoil for our couples and uncertainty. And then we got mixed messages from different departments, which I'm sure you've all dealt with. At the end of the day, you know, we went through, to be quite honest, almost 15 law firms I personally talked to find Tony's firm, who is amazing. They're an amazing firm. And at the minute I talked to him the first time, I knew that these were the guys we needed. And obviously, as the results we got Friday show that they know what they're doing. And Tony, you know, you've been great. And I'm excited to finally be able to introduce you to the rest of the venue world and, you know, the man behind the scenes. Let's pull back the curtain and go ahead, man, run with it.
Well, thanks, Clinton. Thanks for the nice introduction, and Theo as well. You know, I'd be remiss if I didn't give credit to my constitutional law team here at the firm, including our Saratoga office with Phil Oswald, our managing partner out there, and Mike Brandy, and also here in Buffalo, Chad Davenport. They did a lot of the legwork under a very tight deadline. For those of you who are not aware, you know, we commenced the case on July 31st, which I believe was a Friday. By that Saturday, we had a scheduling order that required the state to respond to us by 5 p.m. on Wednesday of last week. And then we had an overnight job to get our papers back to the court by 11 a.m. Thursday. Then on Friday of last week, August 7th, the day that the first of the two weddings at issue in the case was going to be held at the Arrowhead venue in Akron in Erie County, Western New York, the judge scheduled what ended up being a 2-hour oral argument. And the Attorney General's office did the primary arguing for the defendants. The county attorney here, Michelle Parker from the County of Erie, was involved at all as well. But we got a very diligent judge who tried to accelerate everything to accommodate, you know, an August 7th wedding that was important to that couple. And important to, I think, all of us on the call, you know, statewide and every wedding and restaurant venue in the state that's trying to do weddings. And the judge rushed a 25-page decision that I think is very well written out before, and got it to us 15 minutes before the couple were going to start their wedding ceremony. So that was kind of the time frame we were on. So credit goes to my team at Rupp and our constitutional law department, and appreciate Clinton's confidence in us, and we were glad to deliver this result. So where are we now? I know a lot of people have read the decision, or at least heard about the decision. They're kind of wondering, you know, to what extent and what scope does it apply? Is it just these two weddings? Is it just the Arrowhead venue in Akron, New York? And what I can tell you is the judge deliberately wrote this decision in a way that it was clear to me that he intended the import of his decision to apply statewide. Now, when you choose to serve a complaint on behalf of individual plaintiffs, these two brides and bridegrooms, and a minister that we threw in to give color commentary to the religious aspects of a wedding, but it was basically these two wedding parties. You know, the law says that the injunction that's issued is technically only with respect to those parties. Now, this judge knows that technical rule as well, but he wrote the decision clearly in a way that expands it to all similarly situated wedding venues that are willing to comply with the restaurant COVID-19 protocols and safety standards, as well as any weddings who are willing to do that as well. So what was clearly important to this judge's decision, which was founded on equal protection grounds, was that the wedding venues were all willing to comply by the restaurant guidelines. And the wedding party itself was willing to dispense with the normal wedding things that you would do, dancing, mingling, hanging out at the bar, and basically have dinner there at the restaurant facility in Akron, and not do a lot of the wedding things. And that was what carried us over the top, because what the judge reasoned in his decision, and I'll save you all the trouble of reading through a 25-page decision that's full of a lot of legalese. What he said was, look, if this venue can be open Monday, Tuesday, Wednesday, Thursday at 50% occupancy for restaurant diners and patrons, there's no reason why on Friday night it cannot be open to 50% occupancy capacity for a wedding, as long as those people are sitting down and basically having dinner. And so it was critically important that we lined up the case to show an identity between the restaurant diners on Thursday night and the wedding diners on Friday night. So one of the questions that I know that's been asked as well, are the rules going to change? Is the governors, are we going to be allowed to have dancing? Are they going to relax some of the other rules on the bar? And the answer is, no. The standard that we were under here was essentially what's called a rational basis standard, which meant that all the government had to do, all the state had to do here was prove that there was a rational connection between the regulations or the guidance that it had promulgated and the public health concern of COVID-19. But the court said, look, there is no difference between a restaurant operating and calling it a wedding the next night if you're going to follow all the same protocols. So, the judge said, and this is in page 24 of the decision. If those of you who haven't seen it, I'm sure that somebody on the call, and I'd be happy to give you a copy of it. But the judge said in relation to whether he expected his decision to have import beyond just these two weddings. Now, he's a very bright guy. He's the former U.S. attorney for the Northern District. He's the chief judge of the Federal District Court for the Northern District of New York. So this guy's no dummy, right? So when he wrote his decision, he could have said very easily, over 25 pages, my decision is restricted to these two weddings. Don't think for 1 minute that this goes to any other venues or any other weddings. It's these two weddings have proven to me that they should be allowed to proceed in excess of 50 people. What the judge said instead on page 24 of his decision, he said, rather, the court is finding that a wedding that follows all the same rules that would be applicable to the given venue for dining, when that venue is operating as a restaurant, should not be treated differently from a restaurant. So he's clearly referring to other weddings. He's clearly referring to other venues. And in my view, and I can't speak for the judge, but in my view, having done this for a number of years, he was saying that this rule that I'm laying down is going to apply to anybody else who is willing to abide by the restaurant safety protocols. You can have weddings in excess of 50 people, just like you could serve diners in excess of 50 people the day before. Now, as a technical matter, the state can take the position that it applies only to these two weddings. So the next question, obviously, to be begged is, how do we take this decision, which is a good foot in the door, and turn it into a decision that can benefit, every venue that's trying to hold weddings, and every wedding party that wants to have a guest list in excess of 50. So my team and I, in consultation with other external attorneys who are knowledgeable in constitutional law and federal procedure, have come up with a couple of different strategies. We are trying to narrow down exactly what we're going to propose, but we're either going to propose bringing another lawsuit in the Northern District, this time on behalf of multiple venues, hopefully trade associations representing other venues, and some brides and grooms thrown in for good measure to try to widen the scope of this. There's a rule that makes a lot of sense from a practical standpoint that says that once the state is lost on an issue like this with a full briefing and a full opportunity to be heard, they can hardly turn around the next time other parties bring the same matter before the court and say, well, we want you to come up with a different decision. So the precedent of this decision should carry us if we bring another proceeding in the Northern District. Or one of the things under consideration, we have the ability to amend our complaint as of right, because it's literally only 10 days old. We filed it on July 31st, 10 or 11 days old. We have the right to amend, to add other parties to the caption of this case. And that has the advantage of making sure that we keep Judge Sotheby as our judge. And I think he would be loath to reconsider his decision, as long as everybody who is on the same page, that they must agree to abide by the restaurant, what I'm calling the restaurant protocols. I understand that the executive order applies to not just restaurants, but catering venues and wedding venues and banquet halls. But comply with those guidelines. Have a written COVID-19 preventative plan in place. Make sure that your wedding patrons are not dancing and cavorting from table to table like a pre-COVID wedding they would do. As long as we can present to the judge that we're willing to do that, he's willing to agree that wedding patrons and venues can be trusted to follow the other laws relating to social distancing and everything else. In fact, it came up on the call when the state said, well, we can't trust people at weddings. He said, well, how can you trust restaurant patrons dining out for dinner? And she said, well, that's different. They don't know each other and blah, blah, blah. And we pointed out that, we could book, I could get 12 of my friends each to book a table of 10 and bring 10 more of my friends and have 120 people there who all know me. But if we're out dining, that's okay under state regulations. But if we call it a wedding, all of a sudden we can't be trusted to follow COVID-19 protocols. So the judge was very taken with those arguments, but I want to stress that the import of the decision hinged on the equal protection arguments under the 14th Amendment of the U.S. Constitution, which said that, if there's going to be special rules for some people that are not extended to others, the state has to articulate a reason for that, and it's got to be a cognizable one, and it can't be pretextual. And the court essentially found the distinctions that the state and the AG's office were trying to draw between dining patrons on a Thursday night and wedding patrons on a Friday night, concluded that they did not bear a rational relation to any public health concern, and that they were pretextual and the state should be enjoined from enforcing them. Important to that was the court noted that the state had allowed high school and other graduation ceremonies in excess of 150 people and didn't seem to have a health concern about that. Obviously, the recent protests came up with the governor and the mayor of New York City endorsing protesters who were meeting not by the scores, but by the hundreds and maybe the thousands to protest police brutality, and seemingly had a de facto exemption. So when a law of general applicability like the 50-person limit is not is riddled with exceptions, and those exceptions are not applied to other people who were similarly situated, it's an equal protection violation. So here's where we are, folks. The state has come out and said in press releases from the governor's office, they've said simultaneously that this is a terrible decision by an irresponsible judge that could open up New York State to large parties and jeopardize the health of New Yorkers. It's also said that it's limited to just 2 weddings. So which is it? I know some reporters are asking the governor's office to try to clarify those 2 irreconcilable statements. But we know that locally here in Erie County, where the venue is located, was going to host these 2 weddings. The county attorney has already indicated that this decision is limited to those 2 weddings. We disagree with her. We wrote back. She's maintaining that position. So what it comes down to is, as long as the state has the police arm of the Department of Health and the SLA ready to pull operating licenses and liquor licenses, it can, until this federal judge clarifies and makes it very clear that, his decision pertains to more than just the 2 weddings that were at issue in the DiMartilli case. We're all kind of in this boat where every venue that's on this call and is wondering whether they're going to get their liquor license pulled, as Arrowheads was in retaliation, whether the DOH Gestapo is going to come to their door. And the only way that we think we can give clarity to the state and the venues who are listening in on this call is by going back to this judge through one of those 2 methodologies, which we're going to pin down in the next day or so, either amending the complaint to add additional people and widen the scope that way, or bring another case in the name of those same people in the Northern District. Important to note, Judge Sotheby was the author of the decision, but the decision was issued by the Northern District of New York. And so it's whether we get a different judge, Judge Sharp there, who issued the Seuss decision, which was in favor of religious institutions trying to hold services with more than 25% of their occupancy and attendance, or whether it's Judge Sotheby, or whether it's another Northern District Court judge, it's the court that issued the decision, and they should, any judge that gets it should be loath to revisit the logic of Judge Sotheby's decision. He spent a lot of time on it, and as I said, 25-page decision came out in 4 hours after 2 hours of oral argument. So what we're on this call to ask for, and I'm happy to answer, I see somebody's indicated they might be having trouble hearing. I hope most of you can hear me. We're here to ask for the assistance of the folks on this call. The Arrowhead Golf Club in Akron, New York, and its co-owners, Clint Holcomb and Lucas James, who many of you may know and have spoken with, have been funding this litigation. Constitutional federal court litigation on an accelerated time frame is not inexpensive. They have funded everything to date and gotten the decision that everybody's, excited about on their own nickel. We're trying to expand that, and they were gracious enough to open their case up, and the law that we've already done and successfully done to the benefit of other people on this call and other venues across New York State. But we need your help. And they've set up a Gofundme page to try to get other venues who have skin in this game to help them defray the cost, not only of going forward and developing more venues and trade associations into this decision and getting the protection of the preliminary injunction that Judge Sotheby authored and issued, but also to help them defray some of the costs that have gotten them to this point to date. And I know that many of the people on this call have talked about this, whether they wanted to sue, whether a trade association should sue, who wants to be the first ones to stick their necks out. Well, in this case, it was Arrowhead Golf Club, and it was Clint Holcomb and Lucas James who did that. So those of you who want to get the benefits of this decision, you can help us in a couple of ways. Most importantly, I think you can help to refund some of the money to Lucas and to Clinton and allow us to go forward by contributing to the GoFundMe page or making other arrangements with Clint or Luke to contribute. The other way you can help us is by becoming one of those plaintiffs in the next case. Whether we're amending in or whether we're bringing a plenary action, we need forces. We need people to band together on this, to hold on to this decision. The state has already filed a notice of appeal. The Second Circuit is going to take this case on an interlocutory basis because it involves equitable relief. What kind of a briefing schedule they're going to be on. I know the Seuss case, I believe, is not scheduled for oral argument or scheduled to be heard anyway until November. So we may have some time there, but they may also see the media buzz about this decision, and the court may expedite things even further, and we may be arguing in Manhattan on this case in September, trying to hold on to this decision, which we think is well reasoned and is correct. But those litigation steps all are going to cost money. They're going to involve legal work on our end, and we're hoping that enough people will step forward and enough trade associations will step forward to help defray those costs, so Clint and Luke are not paying the price. Because as many of you know, they've already paid the price. Because the day before this decision came out on August 7th, the State Department of Health, or the County Department of Health rather, issued a cease and desist order, and the SLA pulled the establishment's liquor license. So the first of the two weddings proceeded on a dry basis because the establishment had lost its liquor license, and obviously it's a misdemeanor to serve alcohol without one. And so I would say that Arrowhead has really paid for being the first venue in the state to take the governor on head on these wedding restrictions and regulations. And I know as somebody who has not liked the overreach from government on many issues since this COVID-19 crisis began, I'd love to see people stepping up and offering both their moral support and their financial support, and the names of their entities and venues to the lawsuit or the amendment in that we're contemplating. So I'm happy to take some questions. This is, I will say, prefacing my answers, that this is a complicated area of law. There's not exactly a lot of decisions out there in a pandemic situation to guide either courts or lawyers or litigants and how courts are likely to rule. There were some pandemic cases dating from the 1918 Spanish flu that we could use, but some of this is uncharted territory. So I'll do my best to field and answer your questions. I hope I've answered some of them already. But recognize that, we're doing our best to navigate waters without really, much of a map to go on. So we can make our best judgment as to the best way to proceed, but we, don't always know for sure. And some of the questions, can be answered, but I would need to get off the call to research them. So I'm seeing a question from Ann Tandle. It looks like, does the 50% capacity include hired vendors, i.e. the catering team? I would say yes, that anybody on premises, again, I don't know if there's guidance particularly on that. There's not going to be any case law. I would say that the 50% capacity would include all people on site. I mean, I think if you think about it from a health standpoint, what the state is trying to regulate is the number of bodies. So it doesn't matter whether they're guest bodies, employee bodies, or, but I could be wrong on that. It could be that it's only the guests and support staff and wait staff are in excess of that, if somebody knows.
Tony, I think that, of course, in the judge's ruling, he said to proceed under, restaurant guidance. And if my memory serves me correctly, restaurant guidance is that employees do not count on the 50% capacity limit. So,
that's good, and that makes sense, and that's helpful because it gets us to higher numbers, especially facilities, that don't have the huge capacity that Arrowhead has.
Exactly.
Yeah, I think I've seen it written somewhere under the SLA guidelines that the 50 people or 50% capacity was strictly on guests.
Okay, that's
But
good.
I could do a little bit more looking into that because it's out there. Tony, a couple of questions that came in further. One is the relationship of venue versus restaurant. So if there's a standalone venue that does not have a restaurant, are they still part of this because we're talking more about how a venue could be like a restaurant, or do they have to have a restaurant?
So it's my understanding that, venues, downstate, I think they call them caterers, and upstate, maybe more banquet halls and venues, wedding venues, apparently are subject to the same, what I've been calling restaurant guidelines under the same executive order. And believe me, it's a patchwork quilt of orders and guidance that have come out from the governor's office in a very disorganized fashion with these executive orders. So it's tough to know. But look, in long-winded answer to your question, the parts of the decision that I believe are, clearly what the judge intended. I will go a step further and say, I believe the judge intended to allow any party, not just a wedding, but any group of people who want to go to a facility and hold their event, whether it's a swim team's awards banquet or, the bowling league and its end of year party, as long as the venue is already open and subject to what I'm calling the restaurant protocol, and is willing to abide by it. And as long as the guests are willing to abide by that, it doesn't matter whether you're a wedding or not. And why do I say that? Because when we brought the case, we tried to emphasize the religious aspects of weddings and tried to bring ourselves under the First Amendment free exercise of religion clause, hoping that that would give us a leg up against a very, very pro-government standard, this rational basis test that I told you about. Much of the oral argument last Friday related to the religious aspects of weddings, why it's important to have family and friends there to see the rite of marriage, the sacrament of marriage, the joinder of two families together. It's all very symbolic. It's all very important to the Christian faith. If you notice, when you read the decision, the judge didn't touch religion, didn't touch it. He ruled strictly on non-religious grounds, not under the First Amendment, but under the 14th Amendment of equal protection. And if you think about the implications of that, what that means is that he didn't say that only weddings can exceed the 50% capacity rule if everybody is willing to abide by the restaurant protocols. He was basically saying between the lines that any group can violate, not violate, but be in excess of the 50 person rule and bring itself within the 50% capacity rule just by agreeing to abide by the same rules that they would abide by if they were diners in the restaurant. And so that to me is, so clearly I think this should be construed and interpreted by the state as applying to any wedding at a restaurant venue. I think it should be applied to any group at a restaurant venue. To Theo's question, should it apply to other establishments, venues, caterers that are subject to the restaurant guide, what I'm calling the restaurant guidelines, the food service guidelines, but are not open Monday, Tuesday, Wednesday, Thursday for actual restaurant trade? And I believe the answer is yes. And the reason is because they're all subject to the same guidelines. The state did not issue a separate set of guidelines for venues that aren't also restaurants. It said, here, these are the guidelines for all of you. So to me, if you can be open to do a wedding of up to 50 and you have the capacity to do more under this decision, you should be allowed to do so even if you're not open as a wedding. But one of the, not open as a restaurant, but one of the things we would try to do in this continuation of the lawsuit or the new lawsuit we would bring with the support of the people on this call would be to get clarification on that and try to bring everybody within that umbrella. If you think about it, it's, and I don't mean to speak against the restaurants on the line, but there used to be an open competition between restaurants trying to host a big wedding and venues trying to hold a big wedding right now. And so now the restaurants have kind of a built-in state advantage if this decision is now the law. Now they can do the big weddings, but the wedding venues can't do big weddings. So I think that it's a logical extension of the decision. But unlike the first two, I think it would be considered an extension, and we would need the judge to weigh in on that. So I hope that answers the question.
Oh, absolutely. That's fantastic, Tony. So here's the big question. By being a part of this next action, or how important is it to be a part of the next action? Because from what I've heard from legal professionals is that your name has to be on it if you want to be guaranteed the ability to have the luxury of the decision. So if I want my facility at 50% capacity, I have to be a part, I have to have my name on this action. How's that work? Is that correct?
So, I mean, so technically that's correct. If the state wants to play hardball, which it's already signaled it absolutely wants to play hardball. Now, sometimes when you get a preliminary injunction, the state sees that the logic that applied to those two weddings would apply to every other wedding, and they say, okay, we agree, we're not going to fight you on this and make you file multiple cases. And the court system's not set up to have every wedding and restaurant venue that does weddings in New York State sue its own individual case, right? But if the state is going to play hardball, and we know the governor plays hardball, and is going to take the position that this decision should be limited to the ink on the page, then the best and easiest way to be able to tell the Gestapo when they show up at your establishment that you've won is to be on the case, right? But there's other ways to do it, and that includes operating through trade associations that represent, for instance, I'd like to talk to the New York State Association of Restaurants and different groups like that, and we are talking to some of them. If they're on the page and they represent multiple venues, it becomes more difficult for the state to say, well, you weren't technically a member of them, so you're not covered by this. The other way to do it that we've talked about, and we're potentially still talking about it, is a class action, where we would seek volunteers to be lead plaintiffs in a case, and we would sue on behalf of all similarly situated restaurants and venues in New York, and we would define the class as everybody who's willing to abide by the restaurant COVID-19 guidelines, but wants to hold weddings where it's going to insist on the patrons of the wedding, the wedding party and the guests adhering to those guidelines as well. Now, when you add class action into the mix, and you're already talking about federal court, and you're already talking about constitutional law, you're adding like 3 or 4 levels of complication that that make you have to kind of wend the thread through the needle pretty well to get there. But that's one option that we're considering as we define the next steps in this litigation, is to bring on a class action under Rule 23 of the Federal Rules of Civil Procedure for injunctive relief, which is B2 of the rule. So that's a possibility too. But the safest way, is to put your name out there and have your venue be one of the ones that we attach to your COVID-19 protocols, and we say, look, we're ready, willing, and able, and have been complying with the restaurant protocols, and we'll do it when we have a wedding too.
Wonderful. That's awesome. So I think that's the most important thing that people are thinking about is, number one, how can I guarantee this is going to apply to me? So the answer of that is you need to be a part of this. And number two is, I just saw the question, is that going to put a target on my head? And, I want to speak to that really quick, just saying, if you're abiding by all the health rules to begin with, people are going to show up at your door regardless. And if you're doing things properly, you have nothing to worry about. So whether they're coming after you every day of the week or whether they don't even know you exist, it doesn't matter, because as long as you're following the proper guidelines, there's nothing that they can do to you that they're not already doing, which has been part of the conversation I've had with a lot of people, being paranoid. Maybe you want to speak to that really quick, Tony, as far as the state having retaliation against people being named in the suit.
Well, the first thing I can say is, folks, there's strength in numbers, right? I mean, we're taking on, a guy I regard as a dictatorial governor who I think is running for president. And I think he wants to have his press conferences and his fawning national media talking about what a wonderful job he's doing in New York. And I think he has no interest in ending this anytime soon, because he's reveling in it, especially now that he can compare New York's contraction rates to what's going on in other states around the country and keep them on his little banned list and everything. So I'm not a fan of this governor, and I think he doesn't really have the best interests of working New Yorkers in mind when he issues these regulations. I don't really think many of them and the continuance of them is really about health anymore. I think it's about keeping a crisis going so he can be the star of the show. Having said that, he has a lot of power. And he's said he's going to wield it. One of the things that's really disturbing to me as a constitutional law attorney is that, he's basically said, you don't do what I tell you, I'm going to sick the SLA on you. And he does. And he's got the Department of Health. So he's got a couple of whooping sticks that he can hit you with. Now, it's hard to do that when the national press, the New York State press, maybe the national press kind of running against him on this issue. All saying that this decision opens up the state for weddings and seem to be met with favorable approval, even by a fawning press. And I think it's, there's strength in numbers, and the more people that glom onto this, I think it's going to be more and more difficult for the governor to clamp down. But can he do it? Yes. But if we win on this second phase, the strategy here was kind of thought out to get a foot in the door with this ruling on the 2 weddings. It's not by accident that there were no venues listed on it. I don't want anybody to think otherwise. This was designed to put our best foot forward, win on behalf of a couple of couples. We thought we'd play up the religious angle because they really truly were devout Christians, and they really did want to have guests and family there to witness the joinder of them as a couple, and the joinder of the 2 families, which is important to the sacrament of marriage and the Christian faith. And, so we wanted to put that best foot forward because we thought we needed the religious angle. It turns out we didn't. Our 4th cause of action was equal protection. The judge said right in the decision that he thought that was our strongest argument. So, and I think I agree with him now. I mean, I really like the way the decision fleshed out. So now it's a matter of taking that decision and having it apply more broadly. But that is going to require some people to be on the lawsuit. It's going to require some trade associations who may have been working with the governor's office to try to negotiate better results here, to kind of, go adversarial on him. And he's a petty man, as far as I can tell. So, it is a concern. I'm not going to kid anyone that the SLA can't show up and do what they did to Arrowhead to other venues. But I do think the more force we have behind this, and the more it's seen as a grassroots movement and a groundswell of support for it, I think the less likely it is that the governor's going to want to take that on. And I think the more likely that he's going to try to steal the show by issuing new guidance that takes things away from the federal judge to tell him what he can and can't do. And he's going to say, well, I was going to do that anyway. So maybe that's coming. And, you never know what kind of buttons, we can push with this litigation.
So you were incredibly fast getting this written up in front of a judge and getting a decision. It was absolutely impressive. So, you gold star to you and your team, because you guys really did an amazing job. And the speed was just incredible. And it really turned people's heads. So the question now is, how fast can this next action be taken, and your idea for turnaround on that?
Well, so that's a great question, Theo. And, I think given the groundwork that Luke and Clint have already had us do, we're in a position to move very quickly. I've been telling people, from green light, from the day I'm green lighted on this, and I know who the clients are and we can get going, we need 5 days to be in front of the court, with amended papers, a new memorandum of law, even strengthened from where it was before, because we've now had the benefit, of course, of the state's opposition, and we've had the benefit of this lengthy decision and the judge's insight on the law. So we can strengthen the papers, but the good news is we don't have to rewrite them. And the reason we don't is because Luke and Clint have already funded us to this point. So anybody who's on this call and is interested in being part of the second phase is going to benefit from the work that's already been done. And that's the reason why, on behalf of Arrowhead and its owners, I'm suggesting that the Gofundme page is really kind of a contribution to what's gotten us to this point to date, and what can get us to an even better position going forward. So I'm looking at 5 business days. I think my team is up for it. We had an all-nighter Wednesday night into Thursday. It is August. We do have lives, but we're dedicated to the task. And frankly, you've got a bunch of attorneys here who really believe in this. I mean, this is not, we're not play pretending here. We believe that the governor's, policies here are overreach and showboating, and we would like nothing more than to just see this ensconced in a more permanent fashion that benefits every restaurant and wedding venue across the state, and allows not just weddings. Honestly, I really do think that, because the judge didn't limit it to a religious aspect, that this really allows parties, banquets, the normal types of things we used to do before this crisis hit, to happen, as long as people are just, a little bit safer and cut some of the things out of what they would normally do. And they could still go forward and have 80 percent, let's say, of what they want to be there for. Maybe they just can't do the hugging and the going around tables, and in the case of a wedding, they can't do dancing. But I think that's, that's reasonable. That's a reasonable exchange for the benefit of the public health, and we're not going to change that. So we might as well abide by it and go forward, and hopefully someday this is all behind us. So that's what we're looking at in terms of timing.
Okay, that's awesome, because I think that's the most important thing to venues now is, can we get another decision to salvage some of my events in September, the end of September, October, November. There's still, believe it or not, there's still a few crazy couples out there that want to get married and they're holding out. So, time is definitely of the essence for the fact that these things could actually take place. So that's really encouraging to know. So a little bit more on the legal aspect of it. The next course of action is getting people together, get their names on the next complaint.
Go ahead.
A question came through about the governor's appeal. So there's a hearing for this injunction in November, I guess, right? And so what can the governor do before that happens?
So real quick on just the procedure, when you bring in a case seeking injunctive relief, there's really 3 stages to the relief that you're seeking. When you first file your papers, you ask for a temporary restraining order, which is just judge, until we have a hearing on the preliminary injunction, can you just stop them from enforcing this stuff? Look, we've got a good basis. The judge actually denied that, but it didn't matter because he, instead of giving us a month and a half to brief it, he gave us 5 days. So we didn't need a temporary restraining order. So the real battleground in most of these cases is over what we just fought last Friday, the preliminary injunction. But that doesn't end the case, because the end of the line for this type of constitutional challenge and injunctive action is what's called a permanent injunction. And that actually plays out after you've gone through all of the normal phases of a lawsuit, including discovery, deposing people, and actually a trial if a party can't win it on summary judgment. So, up through the preliminary injunction phase, everything's very rushed and accelerated. After that, the judge in this case scheduled the next part of the case for November, which to me is a clear signal that, he expects that this kind of ended it with the preliminary injunction. But if the parties really want to move forward and fight the rest of the fight all the way out to the end to get a permanent injunction, he'll do that. So in terms of the appeal, I'm not sure, and I think this was your question, Theo, I'm not exactly sure how quickly the Second Circuit is going to, I think they'll take this appeal. They have the jurisdiction to do it because it's injunctive relief. Normally courts won't take appeals in mid-case, the federal courts won't. This case they will, because we sought only injunctive relief and not money damages. So, but how quickly they're going to move on this, I know that the Seuss case, which was the religious venues trying to hold services in excess of 25% of occupancy, that came out in favor of the plaintiffs, that appeal, I believe, was put out, 4 months as well. So I think I heard that was in November. So I don't think the Second Circuit's going to intervene too quickly on this one, but given all the press that it's received across the state, I could be wrong there. They may decide that they need to move in on this one quickly, especially if they, were to disagree with Judge Sotheby. So.
Awesome. That
answer your question? Did that answer your question? I know it was a long-winded one.
Yeah, no. No, more details, the better. And that's part of having you here this afternoon. And again, I can't tell you how much I appreciate it, but all of the venues across New York State, there's venues on here from Buffalo all the way over to the other side of Syracuse, and into the eastern part of North New York, but they all appreciate the time, and people have told me how encouraged they are by this first lawsuit that's taken, or this injunction that's taken place, and all of your efforts. So I think more than anything, people need to hear, okay, what's the next step? How do we make that happen? How do I get my name on the case? If you could touch on that briefly.
Yeah, so what we need to do to get people on the case is what we did in the we used the Arrowhead COVID-19 protocols. There were several different documents. I'm not an expert on them, but Clint and Luke had drawn up, some real good safety guidelines for their venue that I think made an impression on the court, because they were formally drafted, written out, policies and procedures that the wait staff at the venue was going to follow to abide by the restaurant protocols. And they said simply, we're going to do this whether we call it a dinner or we call it a wedding dinner. And, they were written out, they were good, they made a good impression. So for folks that are going to want to join into this lawsuit, we would seek folks who've written out their procedures, can provide us, we can interview them, maybe get, a declaration from the owner of the facility and say, look, we plan to do this and enforce it. And, one of the questions the judge had was, well, what happens if, the AG's office tried to argue that, well, people are just going to be dancing at these weddings anyway, even though the venue says you pulled out the dance floor. And we said, Judge, you trust people to go out to dinner at a restaurant, not do strange things that violate the COVID-19 protocols. Why would you not trust attendees at a wedding, right? So, and it helps though if the venue says we are going to enforce those. Our bars are marked with the right distancing. The tables are going to be. I saw a question like, what are the tables going to be restricted to? I think at Arrowhead it was 10 to a table. That's it, with distance between the tables, and they would just do that until they reach their actual capacity. So. For the venues, we'd want to have people who make a really good put a good face on the case, and are responsible and have written up these protocols to be able to be in business during this crisis. And we're looking for couples that are that are sympathetic. If you got brides and grooms who are willing to sign on, obviously we wouldn't be looking for a financial contribution from them. I think the industry should, but it helps to have actual people who are actually getting married and actually want to give declarations and say they'd like to have more than a random restriction of 50 at their wedding, when the facility can accommodate more under its capacity restrictions. So that's what we're looking for. Our team would evaluate the folks who are willing to stand up, and the associations that might be willing to lend their name to our lawsuit. And we would, some of what's going to take up some of those 5 days of preparation time is that legwork. We need to get that information. We need to get it accurately before the court, and make sure that we put our best foot forward. So we want to pick the right people and the right venues and move forward that way.
And Tony, I want to add something to that. I've done a ton of labor. I personally developed the entire COVID plan. We ran it by our health department. I ran it through a friend of mine who's a COVID tracer, a certified COVID tracer, so a contact tracer as they call them. And so, a great deal of work went in to make sure that was compliant. And of course, there's still other best practices when you get into tables, these sorts of things. If you're at 50% capacity, then you wouldn't need to jam 10 people to a table. So we put in there what the restaurant guidelines are, because that's what we had to go by. But oftentimes we're much less than 10 people at the table, for the very reason that we want to keep people safe. We want people to be healthy, but we want to be able to operate. So we're not trying to do anything, if we can, be less restrictive than the regulations and basically put people in a safer environment. We absolutely do that. When you're at 50% capacity, you have plenty of space. So a lot of these questions kind of get really technical, and truthfully, for those of you who, Tony feels is the good route to go forward with, I can work with you to make sure that you have proper plans in place before we get there, because if you don't have proper plans in place, you really shouldn't be on the lawsuit. It would be an embarrassment to us as an industry. And so, one of the things that obviously Tony and Theo can tell you is, I spend basically all my time right now, the last 3 weeks, carefully calculating and thinking through and maneuvering each of these pieces as to what our next steps are, working through them with Tony. And it takes a lot of time and energy, but we're getting there. And that's what helped get us here, was Tony and I working closely together on each step of the way, and what the best plan was, and how we kind of took this lawsuit to the next step. Some people have asked me, why did we choose a GoFundMe? It's a messaging tool. It's one thing to have it funded. It's another for those who might challenge at the state, challenge what we're doing, to see that we are funded and we're well funded. And that's part of the reason we chose a GoFundMe. We wanted it to be public, that people knew that people were interested in getting involved in this and seeing this happen. So that was kind of what we chose, that method for bringing people in, kind of to contributing to the lawsuit and how we were handling this. So, I've gotten a lot of questions about that. And it also makes it simpler. Tony wouldn't get anything done if he had to talk to every single person individually. So I've kind of been a liaison so that Tony can focus and spend his time actually preparing legal documents. As he said, they worked overnight Wednesday, and the amount of time in which they compressed this legal work into, I don't know if any of you have seen it, but it's a lot of legal work. I mean, it's a book, it's several books. And for them to be handling 70 or 80 calls a week from different people and the time it takes to explain this over and over and over again would make it kind of difficult for him to be getting done the legal work that we need him to get done to fight for our industry. So I want to get some clarification as to, how we got where we're at and why we're handling things the way we are.
Yeah, that's well said, Clint. I think we definitely, if we move forward and we've got a consortium of folks, it would be helpful to me to kind of have the information kind of disseminated down, from just a few contacts, because our team is going to be busy, pulling this together and implementing it. We I'll be very candid with people. We still have to decide, are we better off commencing a separate plenary action? Are we better off amending into the existing action? Are we better off with a class action? The answer to that question is not just a legal one that we want to research and make sure we put our best foot forward. It's also going to depend on who steps forward. So, if we don't have industry associations, that we can say represent, a good portion of the venues across New York State that are hosting weddings, then, we might have to go the class action route and have lead plaintiffs who are purporting to speak to the entire class of folks who are willing to abide by the restaurant guidelines. But if we have a large group, and so it depends on the mix, who we get, what strategy, and it's also going to have to abide the outcome of the research that we're in the process of doing. But, we'll know in the next couple of days, the best foot forward. And by that time, hopefully we'll know whether there's going to be enough support financially to proceed in sort of a mass way that we've been contemplating.
So what's the easiest way for people to move forward? And what's the timeline? So, do they have to make a decision within the next 24 to 48 hours?
Well, look, I mean, the state is going to move forward. They asked us today if we would agree to stay the order pending appeal. And of course, we said no. The county of Erie, which is just one county among 64, or how many there are, told us that, they interpret this as applying only to the 2 weddings that were involved in the lawsuit. And were we going to advise Arrowhead that, they couldn't hold any other weddings in excess of 50 people. And so we responded to them. So, there's going to be some counter moves by the state in the near future. The notice of appeal came through today. The request for a stay came through today. Whether they're preparing, as I suspect they are, papers to file in front of Judge Sotheby, seeking to stay his order, prior to the appeal, as they asked us to do voluntarily or not, I can only imagine that that's going to happen this week. So, it would be good to be able to get papers in cross-moving against that to have the same return date. So, in other words, if the state comes in and says, we want to stay this, Judge Sotheby, will you agree to stay it while we appeal? We want to, and they make that returnable, let's say on, September 1, I don't even know if that's a weekday. We would want to, have our papers in, our amended papers in, our new lawsuit in. We'd want to make that returnable on September 1st too. So it's not just the request for a stay. The judge sees, what we're trying to accomplish as well. So that's the only rush here, that and the fact that unless or until we firm this up and get it, to where it applies to more venues, I think that people are going to be, just increasingly, or not increasingly, but going to continue to be concerned that it doesn't apply to them. It doesn't protect them when the Gestapo shows up at their door. So, that's the only reason for the rush. I do see a question about Turning Stone. Turning Stone is Indian land, so it's not subject to New York State guidelines. That's always a negotiation. So there's dancing allowed at Turning Stone casinos and things. So that's the answer there. That one I can field.
How about the anticipated cost to move forward? So if a venue decides, okay, I want to jump on board, they get a hold of you, what's the ballpark? I know it's going to be split and shared, but what would be a ballpark idea? Are they looking at a couple of grand or 10 grand?
Well, I mean, individual venue, like you said, I would think the individual venues aren't going to pay any more to be on the lawsuit necessarily, because they're going to be lending their name. I mean, I haven't talked to anybody about that. I haven't talked to Clinton and Luke about that. But we just have a need to pursue the next phase of this. I'm going to be honest, we're about 40 grand into this. We've had 4 attorneys working around the clock on sophisticated constitutional law, federal court practice, injunctive relief on an expedited basis. We put a lot of hours into it, and Clint and Luke have funded every penny of it so far. So I'm going to say that I think to get us through to the next stage where we're sitting on a decision is probably going to take about that much again. It's just an estimate, and if we don't spend it all, we'll obviously be happily refund it, but that's just my best guess. So we would need, if 40 venues gave $1,000 each, we're there. If 80 venues gave $500 each, we're there. If a trade association or 2 wanted to kick in a lump sum of 10 grand, we're halfway there. So it's not. There's more expensive litigation. We're in Buffalo, so we don't charge Manhattan rates. My rate is a very reasonable, I think, $395. I'm not charging, $750 or $800 or $1,000 an hour like you see in New York City. So, and I think we bring a very sophisticated practice of law here, right from Saratoga, our office out there near Albany, and here in Buffalo. I'm a Cornell Law grad. I grew up here in New York, so went to law school here in New York. So, but I just happened to situate my practice in Buffalo and started a firm here 20 years ago. So we're not the most expensive guys on the block. So I know that sounds like a lot of money, but shared a number of different ways as opposed to just one, which is what it's been so far. I think it's a very reasonable ask to try to push this over the finish line. I can't emphasize enough how much it was to get this foot in the door. And Clint and I did work very carefully on the strategy and made the decision who we were going to lead with and hope to get a judge to bite. And I don't mean to say we deceived him or anything, we didn't, but, get him to be interested in a case where you have to overcome tremendous obstacles to defeat the powers of government to enact these types of executive orders in the middle of a pandemic. There's a doctrine out there called the Jacobson Doctrine from the 2018 pandemic that gives even more powers to government than it normally has when it's operating under an emergency declaration, which New York State is. And, this judge could easily have mailed it in and say, you're never going to win. There's a rational basis. There's, like they're trying to, I'm not going to second guess what they're doing to try to prevent New Yorkers from dying. You're putting me in a tough situation. This judge had the gumption to do it, and the Arrowhead and Clint and Luke had the gumption to pay for it. And now we're here on the cusp of something good. So we'd like to try to make it law across New York State and get the governor to realize that, he can't buck the Constitution like this, and a federal court under the Supremacy Clause of the Constitution has the right to tell a state government what to do. That's why we're in federal court, not state, because we got a fair hearing out of this judge and he listened. And I think he made the right decision. And I think if you read it, you'll agree. And I think logically it makes the right, it's the right decision. So we think we can carry it forward statewide with the right support. So that's what that's part of the reason this webinar was scheduled. Also to answer your question. So.
And something else too. I know that some of you who are on this call, and I know Theo can attest to this. We had a meeting with a different law firm who gave us a presentation. I won't say their name, but Theo can attest to this, that they told us that for a state lawsuit, not a federal lawsuit, the cost would total about $150,000. And a federal lawsuit, I'm sure you could attest to this, Tony, is not generally cheaper than a state lawsuit. So, I think I don't want us to take the short-sighted approach that 40,000, is going to get us there. This could be more, and I'd like to be in a position to take this as far as we need to go. And if that means the Supreme Court, I'm okay going there. But that means you guys have got to rally behind us. We can't spend that entire amount ourselves for the whole industry, but really this could affect the whole country. This isn't just about our businesses. This is also about our constitutional rights of protection. So to me, I don't want to take a short-sighted approach and say, let's just look at the next step. Let's look at the entire situation and be prepared to do what we have to do as an industry. And I'm prepared. And obviously we've exemplified that, and we're trying to lead by example.
Hey guys, I'm trying to read the, I know Theo's trying to get some questions. I'm trying to read the webinar chat questions that are coming in. And I see a lot of questions, like, well, what can we do? I mean, is the SLA going to pull our license? What if we're all shut down? What if this just results in retaliation? And I would say, look, we got a governor who I think is capable of doing that. But I think there's strength in numbers, and there just comes a time when I think people have to stand up for their constitutional rights. And now you're not just doing it like Arrowhead did, kind of with hope as your only. Now you got a decision. You got a decision out of a respected judge in a respected court who has sided with us and said, we're right. So, so those who maybe would have been reluctant to do this in a vacuum with nothing like that can, I think, at least hearten themselves by the work that Arrowhead has done to get us to this point and say, all right, now's the time I'm going to jump on board because, there is strength in numbers. I am going to put my money where my mouth is. I do believe this is the right thing. And the state can't shut down everybody. And if they want to try, good luck to them. But I think we've seen the reaction in the media has been generally favorable to this decision, and I would say disfavorable to the state's attempt to spin it. And if we continue to keep press like that going, and I've given a lot of interviews in New York Times and local papers, not because I want to be in the spotlight necessarily, but because I want to get this message out and not have it spun by the governor's office. And I want, to get the logic out. I spend a lot of time talking to reporters so they understand the decision, because I think if we get a critical mass of parties and interests and press and reports on this, eventually the governor is going to have to back down. And he'll probably do it in a way that allows him to save the maximum face, and who cares, but if he backs down, we all win. But we got to keep the pressure on to be able to pull that off. And I'm with Clinton and Luke on that's the best way to carry this forward.
So another vendor was asking, can all vendors participate? Florists, DJs, what have you?
Well, so, I hadn't thought about that, but my first reaction, is to say no, because again, one of the hallmarks of equal protection is you have to show that, what one party is subject to, you're identically situated with that party and you're subject to a different rule. So just if anybody's interested in the law, we proceeded on an equal protection class of 1 theory. We said Arrowhead is being discriminated against because Arrowhead can operate as a restaurant Monday, Tuesday, Wednesday, Thursday, but it can't operate under those same rules as a restaurant providing a dining experience to wedding attendees on Friday and Saturday. And the judge agreed with us. That's called equal protection class of 1. We compared ourselves to ourselves and said there's no basis for a distinction in that regard in the law. It doesn't bear a rational relationship to the public health to say it's okay to be a restaurant Monday, Tuesday, Wednesday, Thursday, and not be a restaurant serving to wedding diners on Friday and Saturday. In fact, the judge asked me, he said, Mr. Rupp, isn't there a difference between a restaurant that, people come and they sit there for an hour, hour and a half, and then they leave, and, a wedding party that's there for 5 hours together in the same room? And I said, Judge, most restaurant facilities turn over those tables several times a night. I mean, so under these rules, my venue here, Arrowhead wasn't, again, a plaintiff. I said it could serve 200 people at 5 o'clock, 200 more reservations at 7, 200 more at 9 o'clock. It could serve 600 people over the course of an evening because it has the capacity to do so. And New York State not only wouldn't blink at that, they would encourage that economically. That's fine, they would say, 50% rule. But, if we decide to book the entire venue for 120 people for 5 hours instead of 3 different seatings that night, somehow that's a greater risk to public health. And I said to the judge, I said, which sounds more risky to you? 600 people all hobnobbing and walking and dealing with wait staff and coming and going and out of their homes and not quarantining, or 120 people? So where does the state get off declaring that a wedding is inherently a more dangerous activity than what it's already allowing by exempting restaurants from the 50-person rule, which, by the way, is the law of New York because it's constant and executive order? All of the 50% occupancy stuff comes out of guidance, not executive orders. It's all an exemption. It's all an exception to the 50-person rule. And the judge threw that back to the AG's office and said, what about that? And she said she couldn't even answer it. So, so there's, so long-winded explanation of the law to say we have to bring ourselves under existing guidance and say we'll abide by it. And when you start adding, florists and others to the mix, I would like to think that they will be collaterally benefit from this. Because if weddings are allowed, I believe that the industries that support weddings will benefit from them happening again and happening in larger numbers and happening with larger guest lists. So, but we're going to think very long and hard about who we want to be plaintiffs in this case. And it's possible that non-venue, wedding industry vendors, might find a place in the case, or in another case in a phase 3 if we need to go there.
But so that's an awesome explanation. But on the other side of that, as a wedding vendor, wedding vendors don't work if venues are not operating, and if they don't have the larger weddings, they're not going to be doing, those larger types of business. So, the support is still needed. The support is still important, and more than anything, really, is rallying behind what's going on now, and even more so financially. So, it's going to financially benefit everybody in the long run. So even if you can't have your name on it as a vendor on the lawsuit, supporting actions moving forward financially is going to help benefit everybody indirectly anyways. So we all need to keep that in mind.
Well said, Theo. I agree.
Okay, so I don't have any more questions right now. I really think everybody got a gist of what's the current status, where we're going, and what's going on. I did put the law firm phone number and website in the comments so people could see that and look you up and make contact if necessary. I think the most important thing is the timing. Like you said, the sooner the better. So I think anybody that wants to move forward with something, make that decision over the next couple of days at the most. The longer we wait, the harder it's going to be, but it's definitely our advantage to move quickly. So make that decision as soon as possible so we can get to the next step.
Can you put up the link to the GoFundMe page, or maybe you have already and I missed it, but
yeah, no, let me grab that and I'll send that over too. So again, talking about vendors financially supporting, we have that on our Facebook page. I'll get that. I'll put that in the comments in just a second here. Clint, did you have?
I see a lot of questions that are unanswered, folks, but some of them are honestly very difficult for me to answer kind of off the cuff without any research or knowing more details. And obviously we don't want the call to go too long. So I appreciate all of you participating so heartily in the comment section. And I do honestly wish I could spend the time to answer all those questions, but I'm going to have to punt on most of them at this point.
Well, and any of those questions that are being asked that don't get answered today, feel free to reach out to me and email me directly. There's a lot of information off the SLA website and the NYGov website that has a lot of that guidance information, and I can email links for that information directly back to you. So if you have that question that hasn't been answered, feel free to email me and I'll send you that link. I think the most important thing right now is to remember that, so actually this is a good question. So right now everything pertains to capacity, and somebody did ask me, so once we get through this capacity thing, say we get to the next step, we win another favorable decision, is it at that time we talk about the other guidelines? Like I want to be able to dance and, do these other things that they're biting down on, or does that become part of a class action?
Well, so, and that's a good question, Theo, but, the dancing, the government could probably come up with a rational reason why they're prohibiting it. Okay.
Okay.
So it's only that they're already allowing us to do what we want to do. They're just not allowing it if we call it a wedding. That was the equal protection class of one argument. When you start adding other things into the mix that sound like they're just sort of incremental enhancements, you remove yourself from something that the state has already said you could do. So that's what's critical. When you challenge and you just say, I think that's unnecessary and I don't like it, that puts you in a different, review category that's very, very, very favorable to the government and quite honestly not likely to prevail. So,
Gotcha.
those things I think have got to be more like negotiated with the state and try to, convince them that it really isn't a danger. But, they may have the upper hand saying that dancing involves, being too close, and now you're exerting yourself and people are breathing. They've said that if you're even singing, more COVID particles go in the air. So if you're dancing next to somebody and swinging them around, so I could see them persuading a judge that that is a greater risk to public health. And I think that would put us in a category of difficulty in terms of getting those incremental changes. But that's something that, we could discuss down the line, depending on how the second phase comes out, which we expect it to come out very well if we pursue it.
Wonderful. Yeah, that's a great answer. And I think some of those smaller guidelines can be worked out between vendors, venues, and the government. So especially once they get to the point where they realize they do have to start working with the businesses to move forward.
I mean, I'm hoping eventually, this will start to become like more symbiotic, where the government is working with businesses who are trying to stay afloat and trying to get economic activity rekindled in New York. Right now, I'm not at all convinced that a lot of this isn't politically driven. But someday I think that's going to change, and I'm hopeful that there'll be a more collaborative relationship than there is now. Because right now it just feels like we're living in a dictatorship. I don't know if anybody else feels that way, but I do.
Oh, most definitely. It's been so challenging, especially because the legislature has given Cuomo the power to write his executive orders until April of 2021. And if you don't know that, that's to everybody that's out there, that's the deal. So, a few venues said, well, maybe he'll loosen guidelines, come the fall. There's no guarantee of any of that. And if we want to be able to have some sort of guarantee that weddings can take place at least at 50% capacity next season, either spring, something has to happen now.
When this started in March, I told people, much to their angst and disbelief, that we were going to be shut down all fall. And many people said, no, we'll be open by mid to end of the summer. And I said, that's simply not going to be the case. And I was telling people this in March and they didn't believe me. But I said, I'm willing to wait and see. But here we are, of course, today, and we're still not open. Now that we have this ruling, we've opened the door to this. And ultimately, for Lucas and I, we just discussed this before the webinar. We're at a place where, we can defend what we've won for Arrowhead. We can work with Tony to defend that, and that's, not going to be nearly as expensive for us. Or we can bring in the entire industry to kind of take it to the next level and solidify it for everybody. And we're open to doing that, and that decision needs to be made in the next couple of days. And so a lot of that is dictated by the support that we get from people. We've gotten a lot of lip service, not much financial support. When you put $40,000 out and you don't get financial support, it's one of those things where you just say, you know what, I guess people aren't that interested. And like you said, Theo, April of 2021 is when he's willing to relinquish control. So how do you guarantee for your couples that you're going to be able to have their weddings even next year? And this is how we need to make sure, while we have time now, that we continue to press this fight. And that's my plan, at least for my venue and for my couples. And I would love for the industry to be involved, because we have a great opportunity right now where we have the momentum. And if politicians, we need politicians to come out. This is kind of our current process this week. And I'm in touch with some right now, local politicians, whoever they are, like the Onondaga County Commissioner who came out. We need people like that to come out and say, yeah, we clearly understand what this ruling says. We need that support from our local politicians that we elect to push them back into this process, because it's a democratic process. That's what it's supposed to be. And right now it's not. We need our politicians to voice, hey, we approve of what the judge said. We want to be involved in this process. This is how things are supposed to operate. So if politicians, if you have a line to them, get them out in front of the media, get them out, kind of talking to people about this, because this is where we need to be. Like, we need to get this out in the forefront now.
Awesome. One last question, Tony, and then I think we'll wrap up, because you've done a great job explaining in detail everything. I just wanted to touch up base really quick on what Clint said about the county executive, Ryan McMahon. He had a press conference yesterday, and during his press conference, he said that this is good news for brides and grooms and for weddings, and it will allow people to have larger weddings. Now, it kind of sounds like he has he's given the green light, and he's telling his county health department to back down and let things happen. Is that what he's saying?
I have to admit, I heard about that, I think yesterday or last night, and I haven't had a chance to read his, but your account jibes with what I've been told. And I think that's great that he came out that way. And yes, the Department of Health in New York State operates through the counties, and he's basically told his county Department of Health, that we are interpreting this the way I interpret it, which is that the logic of it clearly applies to any restaurant venue, at least, if not also wedding venue, that is willing to operate at the 50% capacity rule and follow the protocols for COVID, even for weddings, and the wedding parties are willing. He's not going to mess with them. So, the other enforcement remains out there and in play. And our judge said that. He said, look, this decision doesn't mean that Department of Health can't come in and make sure that, social distancing guidelines are being followed. But it does mean, I think in his county at least, that no way is his county health department going to go out there and start citing people who are over, the 50-person rule if their capacity allows it. So I would love to see more. At the end of the day, the state doesn't, really have the ability to control the individual counties on enforcement level. So at Arrowhead, they've had Erie County Sheriff's deputies and Erie County Department of Health people come out. I don't know that a single person has come from Albany to look at Arrowhead. So the enforcement happens through the state, or through the counties rather, not the state. And if more and more counties see the light here and join into that, and we're actually trying to do some of that, but these folks are politicians, and I guess in Onondaga County they really, and I spoke to a reporter out there, and they really want to see the wedding industry reopen. Among other things, Onondaga County rents out its convention center for big weddings, and they probably like to get that revenue.
Absolutely. Yeah, well, and they're one of the small regions that's been advocating for opening up, and they've been actually working with local businesses that really want to do that. So that's really been a bright spot in what's going on, and again, really important for them to be able to look at what the work that you guys have done and have that same kind of interpretation that you have. So that's really exciting, and hopefully that will help. So
I understand one other thing, Theo. I was told today by a reporter that they have their county law department writing up, an actual opinion to undergird and support what was declared. That's their interpretation. So it'd be great to see. It's almost like an amicus brief if I can get my hands on that. If the county of Onondaga law department supports what we're saying, that could be and that gets released publicly. That could be very, very beneficial to other county health departments across the state. So, I'm not counting on it, but it would be great if it happened.
Well, and I wouldn't doubt it, because the way everything's moving so quickly and spreading like wildfire, it's good news. Things are happening. So I don't want to take up any more time of yours, Tony. It's been amazing that you've again taken today to do this, and Clint, we really appreciate you spearheading things. Any closing comments for you guys? No, we're good to go. Okay,
well,
so
thanks everyone for your time today. I appreciate you being on the call, and I look forward to working with you if we can work it out.
Okay, stay in touch. Thanks, gentlemen.
Thank you. Thanks, Dave.
All right, bye-bye.